And this is Matthew Hill from Hill and Ponton here with Commander John Wells. We appreciate you all joining. Good afternoon, John. We're looking forward to talking to you all today about blue water and the changes with Agent Orange after the Gray decision and where we're going from now. For those who don't know me, I'm an attorney, private attorney with the firm, and we represent veterans across the nation. We've kind of fallen into representing a lot of veterans with Agent Orange issues. And John, why don't you introduce yourself real quickly?
I'm a retired Navy commander and also Executive Director of Military Veterans Advocacy. Worked along with John Rossi in the Blue Water Navy to try to get Agent Orange benefits for Navy vets. We've done that both through the courts, Congress, and occasionally meeting with the VA.
All right. So let's see here. So there's a couple different topics we're going to cover. We want to start with the basics and go over what the Agent Orange Act was, and let's see, and then look at the case that frankly put us where we are, the Haas case, where the VA was able to make what we would consider arbitrary decisions on where the line is. Then we're going to look at the concepts of brown water and blue water, the case that the Gray case, which is where we were able to get the VA's interpretation of at least harbors and bays thrown out. And then after that, we're going to talk about where the law is now and what you could do to use it. Let's see here. So first of all, with the Agent Orange Act, veterans were fighting the VA and Congress for years to recognize the deleterious effects of Agent Orange, those who were exposed and all the disabilities that came from that. And finally in '91, Congress came out with this act that allowed presumptive service connection for certain disabilities. And the act actually called for a two-part presumption. The first part was if a veteran had service in Vietnam, they were presumed to have been exposed. And if they were exposed, then they are presumed to be service-connected for any of the diseases on the list, which now I believe total 15. But the catch then, as it frankly still is what is service in Vietnam? And that was loosely defined as boots on the ground and inland waterways. So for the first 15 years or so, the presumption was handled rather loosely as far as, again, what was in Vietnam, service in Vietnam. There were plenty of decisions showing that when a veteran had a Vietnam service medal, that equaled service in Vietnam, but there were other ones demanding much higher proof of boots on the ground. You know, and all this came to a head in 2006 in a case we call Haas, where a veteran was claiming who was off the shore in blue water that he was exposed to Agent Orange and he should be getting this presumption as others were that just had a Vietnam service medal and not actual proof of boots on the ground. And the fight was the VA was arbitrarily drawing a line right down the coast, saying if you were off the coast, then you were not presumed to have been exposed, but if you were onshore, even for a couple hours, then the presumption was that you were exposed to Agent Orange. And so it didn't matter how close to the shoreline you were. If you were not on the other side of that sand, then you didn't get the presumption.
Just a little bit of, Matt, just a little bit of history is this all started in 1997 when the General Counsel's office looked at the statute and said, well, it says air, land, or naval service in the Republic of Vietnam. They assumed that to be the landmass, not realizing that the bays, the harbors, and the territorial seas were actually part of the sovereign territory of Vietnam, and in fact, the United States had recognized that in two separate treaties.
And so what ended up, what I believe was quite a reach is that the VA said not only is it if you're offshore, but also if you were in a bay or harbor, they did not consider the major harbors to be brown water or inland waterways, but said that they were actually part of the open sea, even though they were all, frankly, within the coastline of Vietnam. And this was their reasoning. They just said that they were open to the sea, they were deep water, and as a result of that, they're saying that these harbors were open water, and therefore the veterans who were on a ship in one of these harbors were not presumed to have been exposed to Agent Orange. So with the Gray case, we had a veteran who was on a ship in Da Nang Harbor. He never went ashore, but his boat anchored there several times and actually tied up to another boat that was docked. Another ship. And our argument was, look, this is an inland waterway. It's not outside the coast. It's surrounded by land on all three sides. And we were saying that the interpretation of the VA's regulation, their own interpretation, was overly broad as to what blue water was, and that bays and harbors are brown water and shouldn't be called blue water.
And actually that makes a lot of sense, because despite what the VA kept saying, those harbors were not really deep water ports. Da Nang Harbor varied between 27 and 32 feet. The Nha Trang Harbor, which is about the deepest, was about 90 feet. And this Agent Orange mixed with petroleum would wind up floating, falling to the bottom, and the effect of the ships entering and leaving port and actually anchoring would continuously stir this up. So it would become the gift that gift that kept on giving. In addition, all of these harbors have rivers running into them, and the Agent Orange that was sprayed on the riverbank or on shore, then was washed into the to the rivers, would then float right out into the harbor, where it would be taken up into the shipboard distillation plant.
So fortunately, the court agreed with us in that the VA's interpretation was arbitrary, was irrational, and that the presumption, as it was originally created in the original Agent Orange Act, the presumption was related to exposure, not the features of the topography of the coast or the ground. And the court said that the VA had to look at this to understand this, or to basically tell veterans that they're exposed, or that they were given the presumption or not, due to whether there's a likelihood of their being exposed. The VA came out and just said, well, this is blue water because it's open to the sea, and didn't give any consideration as to whether there was a direct exposure or direct spraying in the harbors, or I think for us even more importantly, whether there were rivers just feeding into them that were dumping the dioxin directly into the harbor.
And there's no question that Matt Hill and his group did a fantastic job on Gray, and a fantastic job of convincing the court that what the VA was doing was arbitrary and capricious, and really that the court actually called it irrational. And that has forced the VA to do a lot of soul searching, and they have been directed by the court to revise the regulations.
And that's where we are now. The case is back at the Board of Veterans Appeals, but what we've seen in that case and several others is that the Board of Veterans Appeals is waiting and looking towards the central office to decide how it's going to interpret the regulation at this point. And when they do, the court was very explicit, as we just stated, that the interpretation has to be based on exposure, where the Agent Orange was sprayed, what the likelihood was, and they can't just come up with these arbitrary discussions of depth of water and openness to the sea. Incidentally, there's, as John said, the water is not that deep, but the VA didn't even define what deep water was or how deep the water needed to be to dilute the dioxin so much that it wouldn't expose a veteran. So we are in a holding pattern as advocates, and of course as veterans, as far as what the VA is going to do. But I think the hopeful thing here is they have to do something substantive. They can't just throw something else out here arbitrary and say the same thing in new language.
Well, we do know that they came out with a regulation that was just completely, it didn't have a lot of sense to it and didn't answer what the court had directed. Now, and I think Matt will address that later on, but through our efforts, we were able to get that thing pulled, even though it did cause a couple of Board of Veterans Appeals cases to be denied because they were relying on that draft regulation that was never really published. Now, I did meet with Sloan Gibson, the Deputy Secretary of the VA, on July the 6th, and kind of laid out the blue water case to him, not just for the harbors, but all the way out to the territorial seas and beyond. We have a follow-up meeting scheduled on September the 18th, Friday, September the 18th, with Sloan Gibson and Rob Neighbors, who's the VA Chief of Staff. And we're hoping to get some kind of substantive information from there as exactly what direction they're going. I can tell you one thing, if they go the wrong direction, there's cases in the pipeline and they'll still hear from us.
Yeah, I mean, it's a great position we're in as a group in that John and I we ended up getting a couple cases where the VA, or the BVA, the Board of Veterans Appeals, denied veterans based on an unpublished draft interpretation of this regulation. And it was basically, it was the same thing with a couple more sentences. It was talking, again, about depth of water. It was talking about openness to sea, none of which were defined. And one of the more amazing things I've seen in this practice was when John sent a rather stern missive off to the central office. They came back and they said, well, we never published that, and that was never meant to be our interpretation. So from my stance, it's pretty clear the VA realizes that they've erred here. The state of the law is incorrect. And I'm hopeful they're going to make the right decision with this when they reinterpret it. But I was going to say, while we're kind of in this holding pattern, though, I think we need, as veterans and advocates, need to be proactive in what we're doing. And I think Gray gave us a couple good takeaways. And the first was, again, it's the VA's burden to state how harbors are not inland waterways. So if you were in a Cameron Bay or Da Nang or any of the other waterways and you don't have positive evidence that Agent Orange was used there, at this point it doesn't matter in that the VA is the first one that has to show that it was not there. The court was very explicit that the VA had the burden to show why these harbors were not inland waterways. And that's extremely important because finding this information as far as where it was sprayed and when is not easy. And so they're going to have to show that they did this to prove that there was an exposure there. Let's see, a couple other things. The Agent Orange was in waterways, inland waterways, and speaking of rivers. The VA had always said that any inland water ships patrolling up and down the rivers would have been exposed to Agent Orange because some of them are actually spraying Agent Orange. But other of those were not, and the presumption was that they were exposed because they were in that water. Well, if you look at any major port we have here, they're all fed by large rivers. So Da Nang, you've got the huge river from the south, and then one from the northeast. And let's see, Cameron has a large river coming in from the north as well. Same here. Yeah, it's coming in from the north, and then, well, Mekong Delta. We'll get back to that, but Vuitton Bay and Gan Rai Bay. I mean, all of these bays and harbors are fed by rivers, and our argument is what's in that river is the Agent Orange, and therefore they should be recognizing that runoff in the bays and harbors.
And again, Matt is exactly right that runoff has carried that Agent Orange, because again, remember that it's mixed with petroleum, and carried it out to sea. and one hydrological plume. That's where the plume is where the salt water mixes with the fresh water, and it actually becomes quite brackish. But you know, those rivers, especially the Mekong, will go out quite a distance. In fact, the Mekong has about the same attributes as the Mississippi, and the hydrologists tell us that it will go out, you know, probably a couple hundred kilometers in a couple of weeks. So it's a very powerful river, and by comparison, the Mississippi kept the oil out of the Mississippi Delta during the BP Gulf oil spill. You know, went to other places. In fact, it was pushed all the way as far as Florida, but it did not enter into the Delta. Well, the same thing happened, especially during the monsoon. All these rivers would just dump all the dirt, the debris, the grime, the whatever, including Agent Orange mixed with diesel fuel, out into the bays. And one of the problems we've had in the past is, you know, getting the VA to understand that all these rivers would carry out to sea, discharge into the sea, and it would discharge it with the Agent Orange mixed with petroleum. So, and I think during the meeting with Sloan Gibson, the light bulb went on, and he understands it. He gets that. So, you know, it's just a matter of it constantly being fed. Now, during the monsoon season was worse, but the monsoon season, I'll learn to talk here in a second, was actually extended because of cloud seeding operations that we did in the Central Highlands. It was called Operation Popeye, if you want to look it up. But we actually caused more rain to fall, more of the Agent Orange to wash into the rivers, and make the rivers greater torrents that would push it out to sea further.
I was trying to get back to that picture there. The other thing that I think, one of the jewels of this decision is the discussion on river mouths. And for all the sailors out there, I think you got to not think of this as a nautical term as much as a legal term, and that the Court of Veterans' Appeals is saying that basically the river mouth may extend well beyond the actual physical borders, and essentially it's where, you know, the brown water stops and the blue water begins. And as John was just saying with the Mekong Delta, I mean, that could be hundreds of kilometers offshore. And so this is an area where I think veterans are ripe to win their cases. We represent probably over a dozen vets whose ship was off the river mouth of a river. And VA has been denying those by saying, well, on its face, the deck logs say that it's not in the river, it says off the river. And nautically that might be correct, but what we know now from a legal standpoint, that it doesn't matter what they're saying on the river, off the river, in the river mouth. What matters is, what does that river look like? You know, when does the silt end? Is it, if it ends before it gets into the ocean, then the VA probably wins. But if you see the majority of these rivers, it's not that way. I mean, the Mekong Delta, I think, is the most graphic example of that. But almost all of these rivers have the same amount, or not same amount, but it's clear that they're all running out to sea, and the brown water exceeds the physical boundaries of the land. Let's see. The other takeaway, and frankly this isn't so much a takeaway from Gray as an untested theory that I would argue, and it goes like this: if your ship is on the ship registry with the VA showing that it was exposed to Agent Orange, meaning it was in an inland waterway, yet you were not on that ship at the time of exposure, but on it, a couple of years later, I would argue that you should be entitled to the presumptive exposure to Agent Orange as well. And the thought is, if you look at the history of the use of Agent Orange, we stopped using Agent Orange well before our troops left Vietnam. Yet, if you look at the way it works, if a soldier was there in Vietnam, boots on the ground in 1973, even though we were not spraying Agent Orange at that time, the person is still entitled to the presumption of exposure. That to me only means one thing, in that the VA is counting that the residuals of exposure count instead of actually being sprayed. So I would argue in this case, if your ship is on the registry, and even if you were not on it at the time it was exposed or up and in the waterway, that you should still argue that the residuals were there on the ship as they would have been on the land when a veteran stepped on land.
And to give an example of how that works, there was a harbor study to figure out why the coral was dying in Nha Trang Harbor. And 20 years after the end of the Vietnam War, they found traces of Agent Orange in the bottom sediment, as well as where it had impinged on the coral. So that stuff lasts for a long time. There was a case where Monsanto dumped some Agent Orange off the coast of New Jersey illegally, and they found it in seafood 10 years later, over 150 miles from shore, which brings up a good point. We're remediating Agent Orange right now, paying good old U.S. taxpayer dollars to do that in Da Nang Harbor. It gets put into piles and eventually carted off for somewhere. Meantime, you have rains. It washes back into the rivers, into the harbor, where all the fish farms are. And we did some research, contacted the FDA to see if they tested for the Agent Orange dioxin. They do not. And by the way, they only test about 1 to 2% of the Vietnamese seafood, and most of it does not meet the sanitation or industrial waste standards as well. So without trying to get in trouble with the Vietnamese seafood industry, I do recommend you check where your seafood's coming from, either in the grocery store or in a restaurant. And if it's coming from Vietnam, steak, chicken, pork might be a very good alternative for you to consider.
John's become a vegetarian.
I still eat good old American beef.
All right, so let's talk about territorial seas, John.
All right, territorial seas. And
a lot of times people don't understand exactly what the territorial seas are. So let me explain this map that you're looking at. The bold line is the Vietnam Service Medal area. It's roughly 100 nautical miles from shore, okay? And that up until 2002, when the VA implemented that General Counsel's opinion, was the line that you had to cross to get the Vietnam Service Medal, okay? Or to get and also to get the presumption of Agent Orange exposure. Once the VA implemented that General Counsel's decision, of course, all that went away. Now, the next line that you'll see, or the most inbound line that you'll see, is the red line. Okay, what that does is measures, basically you draw a line, connect the dots between the outermost islands of Vietnam, okay? And all of that under international law is considered to be inland waters, okay? From that red line, the baseline, you'll see the dash line. That's 12 nautical miles out, and that is your territorial seas. So anything landward of the dashed line is considered territorial seas. And that's what the bills that we've been pushing here for a couple of years would extend the presumption to. And the current bills, by the way, are HR 969 and S681. You will also notice that those lines end at the 17th parallel. And that's because the original Agent Orange Act says within the Republic of Vietnam. So for example, if you had a ship that was doing, or not a ship, a submarine most of the time, off of Haiphong doing electronic intelligence gathering or monitoring the Chinese off of Hainan Island, they would not be covered by the bill. But any ship that crossed into the territorial seas would be. You'll notice in the south, it's wider. It actually goes out almost to the old VSM line. And at first that kind of gave us a little difficulty, and that's when we started talking to the hydrologists, who assured us that the Mekong River was powerful enough that would extend and push the Agent Orange out to about, to the territorial seas line and actually further beyond. And also, depending on the monsoon and the seasons, the wind will shift and sometimes it will push the Agent Orange and the waves up the coast. Sometimes it will push them down the coast. So the hydrologist tells us that basically anybody in the area marked with that dashed line would have been exposed to to Agent Orange, or to the hydrological plume that carried the Agent Orange out to sea. The only thing that other thing I wanted to mention is most of the territorial seas and all of the bays and harbors are within the 30 fathom curve. And that means basically that they were in the area where ships would anchor. And if you all remember, this was back before digital computers. It was all analog, so the ships would tend to anchor so that they would get a much more stable fire control solution. Because of that, every time they would anchor, that would churn up the sea bottom. And those of you who have been out there know that happens. And also, you got the ships entering and leaving port. And when it does that, that churns up the sea bottoms as well. As Matt mentioned earlier, these deep water ports really aren't deep water. They're actually quite shallow. And all that stuff would continue to churn up, and it became the gift that just kept on giving. Is that understandable, Matt, or did I just confuse everybody?
Yeah, except the last part. I don't know what kind of gifts you give.
Yeah, now he's not telling you the truth. He comes to Washington, D.C., makes me take him out to dinner.
So the territorial sea, I guess we should frame this though. Right now, what we're hoping is resolved is the concept of inland waterways capturing all bodies of water in the coastline with the harbors and bays. The next step here is the territorial seas. John, I think the report next is looking to do that all in one as far as getting extended all the way out to territorial sea. The Gray opinion didn't give us that much. Frankly, it could not, because it was from the Court of Appeals of Veterans Claims, and the court that presides over that is the Federal Circuit Court, and they are the ones who said Haas is all right and that you can arbitrarily draw a line offshore. So
that's exactly right, man.
Go ahead.
But we have hopes. There were some issues with Haas that we would hope at some point would allow us to get that overturned. But the other thing is in working with the VA and on my meeting and hopefully the upcoming meeting with Sloan Gibson, I'm hoping that he'll just go ahead and bite the bullet and extend all the way out to the territorial seas or beyond. He doesn't have to under Gray, but there is always the possibility that they will. The other good thing is currently the bill pending before Congress is projected to cost about $1 billion over 10 years. And there's a separate law that was enacted in 2010 which requires us to find an offset to pay for that bill. It was part of the deficit control bills that were enacted back by, I think it was 111th Congress. The neat thing is if they give us all the bays and harbors in response to Gray, that's going to pull the cost of that bill down to about $10 million a year, or $100 million over 10 years, which it's a lot easier to find pay-fors for that than it is for $1 billion. So, and the other thing that I do have to emphasize is even if we win the bays and harbors, or even if the VA gives us the extension all the way to the territorial seas and beyond, we still need that legislation, because don't forget we had these benefits at one point, and the VA secretary took it away with a stroke of the pen. What one VA secretary can give, another one can take away. So even if the VA gives us the everything we ask for, we're still going to be asking the Congress to pass H.R. 969 and S. 681 so that we can make sure it's never changed. And you all can help, because as I go around the Hill, and I've visited hundreds of offices on the Hill, they do respond to congressional contacts. Now, you may just get a form letter because they get so many contacts in, they have to do that. But they do respond, they do keep a tally. And I can tell when I walk in there, a lot of times we'll get a very good reception, and they'll say, yeah, we've heard a lot about our constituents. Come on in. We really need to find something, more about about this whole situation. And when we first started doing that, they weren't hearing from their constituents. It was not that warm a reception. We had to kind of come in and make the case harsher. Now they're looking at it not only with an open mind, but with a mind of just trying to figure out what the whole thing is about and how they can best help their constituents. So the process does work. I mean, it takes a while, but it does work.
And I'd add to that as well, John, in that I've just been I've been amazed watching this C-123 aircraft debate over the last couple of years, as far as how they developed a groundswell to get recognized that they were exposed to Agent Orange, even though they were stateside, but they were using the old ranch hand aircraft. And I think we're talking about 4,000 individuals total who were on there. But what struck me was the more news and the more negative news, frankly, that the VA got. The VA they wanted it to go away, and I think they ignored it for quite some time. But in the end, there wasn't any studies done or anything on the VA's behalf. But they just wanted that whole thing to go away. And I look at that and I think that was 4,000 people. I think we're talking a group of 80,000 here as far as blue water vets. And,
sure.
Okay.
Yeah, there was one study done. The Institute of Medicine did find a study saying that these guys were exposed. And by the way, the Institute of Medicine presumes the fact that the Agent Orange has gotten into the estuarine waters, and also that the distillation process did not remove the dioxin. It actually enriched it by a factor of I believe it was a factor of 10. And we've had some good public relations. In fact, if you all might want to get onto the Virginia Pilots site over the next couple of days, because we anticipate that there's going to be something coming out from them, as well as, and they have an agreement with a group called ProPublica that comes from the New York Times. So we're hoping for, some more good exposure on this situation. I've got to tell you, I worked with the reporter on this, and he's just fantastic in there. They held us to a high standard of providing accurate information, as they should. And they asked a lot of questions, and they did a major investigation, so I'm looking forward to what I think will be a good story.
And I think that's the key of what we can all do as far as keep the pressure up through this trifecta, contacting Congress, writing to the Secretary, and then whatever reporters' attention we can get, we keep going. I don't know the Secretary, but my impression is that he's a practical man, and he's a pragmatist. He's not, he didn't come into this job with any axes to grind. He's looking to do things right, and I think he's going to. The bigger the media spotlight we put on this, congressional spotlight we put on this, the more he's just going to want to make it go away so he can move on to other issues. So I think we're in a good position right now. And of course, the fourth part there is the court through the Gray decision, making the VA act there. So there's a lot going in what I consider the right direction here.
Yeah, and by the way, when you look at Congress, we now have 264 co-sponsors. That's over half the House. We're trying to get to 289, which basically allows the suspension of the rules. In the Senate, we have 21 co-sponsors. And it's they're broken down pretty well between Democrat and Republican. I'll tell you, we've had great cooperation from both sides on this. You read all about the political issues, and I'm sure it exists, but on this particular issue, both Democrats and Republicans have worked well together. In fact, our lead person in the Senate is a Democrat. Our lead person in the House is a Republican, Chris Gibson out of New York. So, we've been had great luck working with that. If you go to a website, it's congress.gov, and you put in the bill number, HR 969, S681, it'll show you who the co-sponsors are. It'll give you the text of the bill and, all the committee actions. We've had a legislative committee hearing in the Senate. and we look forward to having what they call a markup committee in October to actually mark the bill up and get it ready to send to the Senate floor, and we think that's going to happen. And, ladies and gentlemen, we have never been this close before, with a lot of people, great people like Matt, working some of the judicial things with us, John Rossi from the Blue Water Navy Vietnam Veterans Association, a couple of wonderful ladies, Carol Olzanicki, don't ask me to spell it, and Susie Bellinger up in New York State. Susie's the one who actually drafted me onto this process, and we've been working with a big team effort to push this thing. As Matt says, the more publicity we get, the more things we do, it really pays off. And the other thing, if you look on that website and you see your congressman and senator, or congresswoman and senator have signed on to the bill, drop them a thank you note. You can go on their website, use the contact form on there, and just say, hey, saw you sign on to this bill. It's very important to me. Thank you so much. And I can guarantee you they get a lot of letters, and they're not too many thank yous. It's usually I want, or you so-and-so, or whatever. But, they're human, like everybody else. They like a thank you here and there. And there's some other issues. We're trying to get a Toxic Exposure Research Act through that kind of goes beyond the scope of what we're talking about today. But the more you can thank them, the more receptive they will be. Same time, my organization, Military Veterans Advocacy, you can find us on the web, www.militaryveteransadvocacy.org. We have a Facebook page, which we would invite you to like. We have about 3,500 plus likes on it. And if you so desire to make a tax-free donation, you can do that on the website, www.militaryveterans.org. Right now, we have some small grants. We have some contributions from a lot of folks that have been helpful, and but it costs money to take those trips to D.C., unfortunately. And Matt told me I was allowed to do that, so.
And John has done an amazing job up there. He's constantly, I'm sure they can just hear his steps up and down the halls of Congress again and again, just being adamantly pursuing this. Got lots of questions that I think hopefully we can discuss here as far as what is the timeline. Unfortunately, if any of you have VA claims pending, you'll know this all too well. No timeline on the VA here. They have as long as they want to decide this. What I found interesting is when we got a final decision from, in the Gray case, the VA had about 120 days to appeal the decision. They did not appeal, but within 2 days of not appealing, the BVA had started denying cases based on that draft regulation we talked about. So they're not ignoring this. I mean, they clearly already started looking at it. They had a draft that was more of the same. So my hope is that this will be sooner rather than later. And again, frankly, the more attention we keep on it, the more likely that'll happen, because they don't want any more negative publicity. John had said a little bit before that he's actually going to D.C., I think again next week, to actually talk to the Deputy Secretary about this. I'm hoping that after that he might be able to give us some more time frames. But, this is on their radar, and whatever we can do to continue to keep it on the radar, the faster they will turn this around.
And, it's funny, but, well, it's not really funny, but when they started denying those claims, I sent, as Matt said, a very firm email to Sloan Gibson reminding him that he had promised to consult with us. And within 24 hours, we got an apology from the Chief of Staff. And within a week, we've been told that an email went out to the Board of Veterans Appeals saying this regulation has not been enacted, do not follow it. But, what it does bring up is because we don't have a timeline, it's very important for everybody to keep their case alive. If you're turned down by the regional office, you have 1 year to file a notice of disagreement. Nowadays, it's got to be filed on that silly little form they've got. And then if you're turned down by the Board of Veterans Appeals, you have 120 days to either ask for a reconsideration or to file an appeal with the Court of Appeals Veterans Claims. You've got to make those timelines. Otherwise, you can lose your case based on the fact that the appeal was not timely. And that would be unbelievable. I mean, we have, like I said, we have come closer now than we ever have on this. We've got a lot of support, so you have to keep the case alive. I know some of you are trying to do it on yourself. That's fine. Some of you are using VSOs. That's fine. But when you start, especially when you start getting up to the Court of Appeals Veterans Claims, you might want to start looking at attorneys. And I mean, both Matt and I do those kind of cases, but there's other folks out there too. So, you know, it's you just have to keep that thing in the mill. If you let the time run out, it's considered, in the legal sense, what they call jurisdictional, and you basically can lose your claim. Now, later on, you might be able to revive it, especially if the law is passed, but don't take a chance. The C-123 folks, the regulation that came out granting them the benefits was not retroactive. Okay. Now, if we pass the statute, it will be retroactive. But if the VA issues a regulation, it may not be retroactive. So, you know, please keep those claims alive.
Well, one thing I'd say on that note is that if anyone has had their claim filed or denied by the Board of Veterans' Appeals within the last 3 months, I'd really like to see that, and I know John would too, because that simply means it was denied under a basis that has no basis in law. So I would really like to see one of those, because we already have a couple we found, and we want to both get those appealed and overturned, but I think it's also good to bring to the Deputy Secretary's attention saying, look, this has gone on, this should not be happening. So please do contact us. If any of you don't, make sure you appeal that, because that should be sent back from the court without even having to brief the case.
Sure.
All right. So let's see. A little bit more to what.
Are we set up to get questions, Matt?
We are. I think we've got a couple. I was going to go through one or two more slides. This is, I'm hesitant to put the cart before the horse, but I think it's so important that when this change takes place, when all of you get the recognition that your disabilities are related to service, when they grant service-connected compensation, it is extremely important to realize that that's a battle won, but that's not the war, okay? We represent, at my firm, I'd say 90% of our clients have either PTSD or an Agent Orange disability. And both of those can take a long time just for the VA to admit service connection. But the last thing you want to do is get the service connection and then get the wrong rating, get lowballed on the rating, or get the incorrect effective date, okay? We see a lot of cases where the veteran fought for a long time and then got completely underrated. And was out of, didn't get full compensation they deserved. So just be thinking about this. Once you get the service connection, it is important that the VA recognize that your disability is related to service, but at the end of the day, they need to compensate you adequately. Okay, so just a quick overview here. Ratings are based on your reduced capacity to work. So you need to be thinking that, and I realize the majority of people are retired who are Blue Water sailors, but if you would not be able to re-enter the workforce due to your disabilities, that should be 100% close to it. With the effective dates, I firmly believe that the NEMR Agent Orange Act rules are in effect here, okay? So what that means is that the VA has a very liberal interpretation of when a claim was filed under the NEMR Act. Okay, I put up the CFR, the regulation there for the NEMR effective dates, but essentially the case should go back to when the veteran first filed. That can go back if you filed last year. It can go back if you filed 20 years ago and never appealed. So that is extremely important, because you need to address that issue the first time you get rated, the first time you get a favorable decision. And then, as an aside, I would say that if you have a disease that's not on their list, we talked about the presumptive diseases. Everybody knows diabetes, heart disease, prostate. If you have a disease, let's say like MS or lupus, that's not on that list, I would apply for it unless you know exactly that it came from something else, some chemical exposure post-service or some, it was hereditary, there are folks in your family with it. And my thought is this, they will have to have admitted that you were exposed to Agent Orange now. And if you apply and you're denied, you can apply and basically get a doctor to look at that and say whether the chemicals cause that disability. But even if you're denied, the VA is always updating their list of presumptive diseases. So if 5 years from now they update it and they put your disability on there, the VA has to go all the way back to the first time you applied. So just what I'm planning on doing is once this is passed and once the VA has granted service connection for at least the inland waterways, harbors, and the bays, I'm going to do a more thorough discussion of what to look for on ratings and effective dates, just so everyone's aware. But this is the really important part, because for some of you it could be hundreds of thousands of dollars that they could keep if the effective date and ratings are not adequately done. But as far as questions, there were a couple, and one of the ones that I just saw was Tonkin Bay. There was a question as to whether that was presumed to have been exposed to Agent Orange.
It depends. If they're in the territorial seas, there's no question. It will be under if the bill is passed. The other thing that we have found in most cases that anybody that was in the Tonkin Gulf at some point entered the territorial seas. Your carriers would have to turn around and go into the wind. They would fly in to, if you had an injured bird coming back, they'd get in as close as they could to recover that bird. They'd do search and rescue. There was a number of cases where they may very well have gone into the territorial seas. What, again, you have to do at that point is take the deck logs. On the top of the deck logs, you've got a 08, 1200, and 2000 position. Blue Water Navy, Vietnam Veterans Association has something that you can plug in, okay, and it'll give you with a lat and long, and you can see how close your ship was to a river and a harbor, okay, or into the territorial seas. Now, if the VA only gives us the bays and harbors, that will not include the Gulf of Tonkin, okay, so we're still going to have to push to get these ships covered and get them covered through either through their entering the territorial seas or other ways. One of the things we're looking at in the future is if the mail, the supplies, the people came through South Vietnam, chances are good they carried the Agent Orange with them across contamination. Once it got on the ship, then it just permeated, because people track it through the ship, track it down to the berthing compartments, into the showers. Their clothes will be washed in a common laundry, and before you know it, even if the ship had never come within the territorial seas, but its mail or its supplies or its people had, the helicopters, the planes that would be doing close air support, going through clouds of Agent Orange, all of that was an avenue to get onto the ships. Now, I've made that case very basically to the Deputy Secretary. I intend to make it a stronger case when I meet on the 18th to hope that they will actually come out and recognize that. But what I don't want is anybody who, for whatever reason, did not enter the territorial seas or the bays and harbors to get discouraged, okay, and to throw in the towel. Keep your claims alive. We're not forgetting anybody. It's just that sometimes when we get these things, it's easier to do it in bite-sized pieces. Same holds true for Guam, Johnston Island, Thailand, Laos, Cambodia, Panama, Fort McClellan, and all the other areas. We have to do it in bite-sized pieces, and this is a pretty good bite that we're doing right now.
And this is just referring to some of the things John was just talking about here as far as what to do in your case. If you are if you're currently setting up your case, if you haven't filed for your records, or sorry, for your benefits, I think the best part for anyone is just to get your deck logs. I guess I would forego doing that if you were on the ship during a time the VA has recognized that it was in an inland waterway. But you want to get the deck logs, you want to review all of them, figure out if you were in the mouth of a river, if you're in one of the harbors and it's verified in the deck logs. We've talked about this several times, and John, I don't know if you just mentioned this as far as John Rossi's site has this great Latin long
yes, I did.
plugin you can do, which is great. So you can figure out, even if the deck logs say you were on the, off the mouth of the river, you can actually see where your ship was if it was closer than that. That website is a phenomenal resource in general, and I highly recommend putting that into your favorites. And then, if you're in a harbor or river or off the river mouth, you argue what we just went over in gray. Something else that John and I talked about was direct exposure. He was just describing that as far as Agent Orange coming in with the mail, and that's kind of what you want to do, even if you were not in. This is what I have to do for all the cases that aren't in Vietnam at all, is show, okay, well, was there Agent Orange in the vicinity? And then try to figure out how you can get that close to you. The beauty, I think, of a ship is that if you can show that it was in the water intake system, you don't have to show that you touched a barrel or got on your foot or anything. I mean, you were using that water day in, day out. So that's just something to think about. And John, was there any other thoughts you had on direct exposure?
Well, I've got a kind of a standard direct exposure brief that we put together for one case that it's pending right now, still at the Board of Veterans Appeals, where we've addressed that, and we've given the citations to all the hydrological studies. Like I say, I've got a affidavit from hydrologists that have studied Vietnamese rivers. So, we have quite a bit of evidence that we can put forward. And I guess anybody that contacts me by email, whether they want representation or not, I'll be able to send them all the information that they can be helpful, as long as I know where they were at and whether we're actually in the harbor, in the seas, whether or not it's a direct exposure issue, and so on and so forth. One of the things that you need to do, though, is get the deck logs, as Matt said. Please scan them, and when you send it to us, please don't send them individual pages. It takes a month and a half to download those things. Just try to get them into one file. If you don't know how to do that, somebody like FedEx Office or Office Depot can do it for you, because that makes it a lot easier to go through and review. But at a certain point, you really need to think about representation. But when you're first starting out, happy to answer any questions. I get email questions all the time, and that's the preferable way to contact me. If you send me a bunch of things, I generally don't have a chance to look at them. So send me an email, and that's probably the best. But keep that claim alive. We're continuously going up to D.C. to fight this issue. I've got 3 more trips planned through, I got 4 more trips planned this fall, starting with next week. And again, if you want to assist financially, some of you may not have had a chance to write it down earlier. It's www.militaryveteransadvocacy.org. We take Visa, MasterCard, Discover, and it is a tax deduction. Matt said I could say that 3 times, so you got 1 more coming.
There were a couple questions. One we just got was if a veteran were on a ship and went on a helicopter, went down and picked up the mail in Vietnam, Da Nang, is that considered boots on the ground? And the answer is yes. I mean, the concept of boots on the ground is you can jump on a helicopter, jump back on. We have vets who are stationed in Thailand who would fly over to Saigon, get off, go get a drink, and get back on. And those are all considered boots on the ground. So that's a very liberal standard. And the other question we got was, do and I didn't see the disease, but do we need a doctor to say my disability is related to Agent Orange after we get the presumption? The answer to that is it depends. If it's one of the diseases that the VA presumes is related, then no, you don't. All you have to show is exposure to Agent Orange. If you have diabetes, prostate cancer, Parkinson's, heart disease, once you show that you were exposed and that you have an actual diagnosis, there's nothing further you have to do. But if you have a disability that's not presumptively related, this is what I was talking about earlier, then you definitely would need a doctor, and you'd need the doctor to talk about why the Agent Orange caused that disability. A disease I'm seeing a lot right now is kidney cancer, and the VA routinely will say that's not related. We've had great success in showing that even though it's not a presumptive disability, that it is. He actually, ironically enough, used a VA study out of a hospital in, I think it was Baton Rouge, John, showing that Agent Orange can cause kidney cancer. So you can definitely win that case. I mean, first you got to get them to admit that you're related, you were exposed, to Agent Orange, and then from there you want to show that either the disease is presumptively related or that the doctor gives you a nexus, meaning connecting the two. I will say this about a disease that's not on their list. You will almost never win that case at a regional office. You have to take that to the Board of Veterans Appeals.
And you know, folks, 8% of the people that are denied at the regional office appeal, only 8%. That's unbelievable, because you know, there's just a lot of things you're going to win at the regional office that you can win on appeal. And I urge everybody, if they think that they've got a bad decision, don't give up, don't throw in the towel, don't say, oh, they're not going to give it to me. File the appeal.
And on that note, there's quite a few people asking, should they go ahead and apply? If you've not applied yet, get that application in now. You're going to be waiting anyway, so you might as well get it in so that when this law changes favorably, you know, your claim is already there to be granted.
And if you're a survivor, if you're a surviving spouse, and you're the veteran died of one of the enumerated illnesses, please make sure you get your claim in and get that in now too. And it's important because the claim will only go back to the date of submission. So, you know, if you wait around for a year or so, you could lose a year or so of benefits.
I just want to point out on this page here, you know, we already talked about John Rossi and his organization, but Mike Yates has also done a great job of organizing Blue Water Vets, and he was up there hoofing around Congress as well with John a little while back this summer. So those are two great resources. And again, you know, if you have ship information questions or just Blue Water questions in general, I consider those two gentlemen experts. And I think John talked about earlier, if there's legal questions, basic legal questions we can talk about, we'd be more than happy to.
Right. And I was negligent in not mentioning Mike Yates. He did come up and spend several days with us up in D.C., and we were able to get to see one of his senators and a staff of another of his senators and one of his Congress people. So Mike's done a fantastic job of just keeping things going. If you don't belong to the Blue Water Navy Awareness Facebook page, please join it. And it's one of the pages that I publish on all the time, as well as my own Facebook page, Military Veterans Advocacy. And of course, while you're there, you know, if you want to pop over to the website and make a tax-free donation taking Visa, MasterCard, and Discover at www.militaryveteransadvocacy.org, please feel free to do that. And that's my third time, so I can't say that anymore. Right, Mike? Or right, Matt?
Roger that.
Unless somebody asks, what was that website again?
Well, it's sitting right in front of them. But that's all we have. We do appreciate your time today coming out and joining us. I am going to make a recording of this and get it up on our website. When we do, we will send that out to everyone. There's several people who are not able to make it, so if anyone asks, I'm hoping to have that up on our website by next week. And that will include the slideshow. Yes, it'll include everything. So again, we appreciate it. This battle is not over yet, but we're very optimistic of where we're going and how close we are. Thanks, John, for joining us too. And all your
It was my pleasure, Matt. And folks, we ain't giving up. So we're going to continue to push this until we win. And that's one of the things I think we've impressed on the VA. We're not going away.
Take care and have a great day.
Y'all take care now. God bless.